Thank you. Good morning, all. I will ask that you all bear with me. While I'm certainly used to giving presentations, one of my gigs I do is teach at the JC on a part-time basis. I'm pretty new to Zoom, and staring at a computer screen, watching myself stare back at me is still a little unnerving. But I'm hoping that as the months go on and this unfortunately becomes the new normal, I'll get better at this. But before we really get started, I just want to be sure that everybody can see me, everyone can hear me. And if you can't hear me, or if you need me to talk louder, raise your hand, type a message or something, and I will try to accommodate you. And then I will also start by saying that the law in this area is ever changing. Even as I finished my slide presentation, stuff has changed since then. So I'm going to do my best to try to give you as much up-to-date information as possible. And those of you who have attended other seminars, you might find some of this information similar. I've attended seminars from the American Bankruptcy Institute. I've attended seminars from a consumer group doing bankruptcy. And I also attended a seminar that one of our attendees, Doug Preventure, put on. And as I was typing my slide presentation, one of the things I was warned about was to try to keep it upbeat. And after I saw Doug's presentation that he did for the Sonoma County Bar Association, his presentation was much more upbeat than mine was. So Doug, I apologize in advance. Some of the stuff you see might just look a little familiar to you. But having said that, I'm going to try to share my screen and get started. And Doug gives a thumbs up, good. I'm not sure if his was copyrighted or not. I don't know if I'm going to owe him a few pennies, but host has disabled participant. No, I'm not disabling. It says host has disabled screen sharing.
Try that again.
All right. Oh, there we go. Okay, can everybody see that? I hope everybody can see that. So basically what I hope to cover today is legal alternatives for businesses who might be facing financial difficulty. Doesn't necessarily have to be because of COVID-19, doesn't necessarily have to be because the shelter in place, but my guess is that's probably why most, if not all, businesses are struggling, at least right now. So who am I? My name is James Sansone, but I go by Jim. I've been a practicing attorney for about 12 years. I have focused on family law and bankruptcy and civil litigation. I joined the firm I'm at now, Carle, Mackie, Power, and Ross, in December of last year. Prior to that, I had my own office for about 10, 11 years. I worked with a part-time associate, a legal assistant, and a paralegal. And while I did about 25% civil litigation on my own, my practice seemed to focus on family law and bankruptcy. And I always joked with people that I thought the marriage of those two were perfect because one always followed the other. It just depended on which one came first, the chicken or the egg. Part of my practice is that I also represent both plaintiffs and defendants. And in the bankruptcy court, I have also represented debtors and creditors. So I bring a good knowledge of both sides of the equation. And I consider myself to be aggressive, but also very pragmatic in my approach to law and cases. So what is our objective today? I like this quote from Maya Angelou. It basically says, do the best that you can until you know better. And once you know better, do better. I like that quote because every day is a learning opportunity. We learn new information on a day-to-day basis. And I think this quote is perfect for businesses. At least this is how I ran my own business. I did as best as I could, and then as soon as I figured out a way to do better or gathered more information to do better, I at least hoped that I did better. All right, what are our objectives and goals today? I hope to cover the current and proposed COVID-19 protections for commercial tenants, force majeure clauses and how that might affect commercial tenancy and landlords in the era of COVID-19, a brief summary of the CARES Act and other proposed federal relief that is on the horizon, and a summary of Chapter 7, 13, 11 bankruptcies, including the new Subchapter V bankruptcy. And I'm going to be moving kind of fast because any one of these topics could easily be an hour-long presentation in and of themselves. So today's presentation isn't necessarily to get an in-depth knowledge and make everybody experts on these, but I hope to at least give you a little information so you can make an informed decision on what, if any, of these options might help you in today's challenging economic environment. And if any of you have questions along the way, like I said, I'm used to teaching at the JC, just shoot them out. Unmute yourself and shoot them out. I hope to keep this interactive. I doubt if many of you want to hear me drone on about the bankruptcy code and force majeure for an hour and a half. I know my students don't like when I do that, but I'm certainly capable of doing that. All right, we will first start with COVID-19 legislative protections for tenants. So, as you may or may not know, our governor issued a COVID-19 eviction defense ordinance based on executive order. And for those of you who want to write it down, it is Executive Order N2820. And the order prohibits landlords from evicting tenants for non-payment of rent from a residence or dwelling. I think that's very important, and prohibits the enforcement of evictions or enforcement orders. In addition to the governor's executive order, Sonoma County also issued a COVID-19 eviction defense ordinance, which pretty much aligns with the governor's executive order. Now, what people have to be careful of is, at least my reading of these, is that both ordinances use the terminology dwelling and residence. So basically, in my opinion, the governor's eviction moratorium and at least the Sonoma County eviction moratorium doesn't cover commercial tenancies. Those only give protections to residential tenancies. So up until a certain point, unless your county specifically protects commercial tenancies, which some counties do, Sonoma County is not one of them, at least as I sit here today, it's not one of them. There is no official governmental protection per se for commercial tenants. But not to worry, the Judicial Council of California, which is the governing body for all of the superior courts, has basically issued an order that generally prohibits any superior court from issuing a summons in an unlawful detainer action. And for those of you who are unaware, when I say unlawful detainer, that simply just is a fancy word for a eviction action. Any eviction action needs to have a summons and a complaint served on the party to whom the landlord wants to evict. The significance of the courts not being able to issue a summons is that the eviction cannot start without a summons. And while there was some talk about lifting this emergency order, at least as of today, the courts are prohibited from issuing a summons until 90 days after the governor declares the state of emergency over. And I don't know when that is. I don't think any of the talking heads know when that is. So essentially, there seems to be, at least as of today, a perpetual ban on any type of evictions that don't adversely affect health and safety. So I did have a whole section on Senate Bill 939 that got a lot of press in that this bill, amongst other things, was going to prohibit tenants, excuse me, not prohibit tenants, it was going to allow tenants under certain circumstances to unilaterally terminate their lease and leave. But unfortunately, as of Friday, last Friday, I believe, the California Senate killed Senate Bill 939. So there was too much backlash from what was reported from banking groups, groups that represented landlords. So the Senate has killed Senate Bill 939. So that is no longer a possibility to become law in California. So I'm not really going to go over what it would have done because it's not going to do anything. Although the original senators who proposed the bill are really disappointed that the Senate as a whole killed it, and they are looking at creating bills that provide similar protections, but those bills are likely going to have the same difficulty in passing as 939 ran into. So I'm not going to go into 939 any further except to say that it's no longer on the horizon. All right. Now, many of you probably already know this. This is old news, but I'm just going to summarize it, that the government did pass the Coronavirus Aid, Relief, and Economic Security Act, or as everybody calls it, the CARES Act. And while this program established a whole lot of protections, many of which we're not going to get into, the most popular protection was called the Paycheck Protection Program Loan, or PPP. And that essentially was designed to keep any business with no more than 500 employees able to keep their employees on payroll. It essentially was a loan, maximized at 2.5 times your average monthly payroll, up to a maximum of, I can't see my screen, but I believe it was a $10 million maximum. The interest rate was capped at 1%, and under certain circumstances, your monthly payments on that loan could be deferred. But the best part of the act wasn't necessarily the deferral payments, is that if you use the loan proceeds properly, and that was subject to debate on what properly really meant, that the loan not only could be 100% forgiven, the business would suffer, or the individual would suffer, I should say, no tax consequence for the forgiveness. But it was really tricky to figure out what parts of the loan were forgiven. And that really goes beyond the scope of the presentation, except to say that as originally drafted, no more than 25% of the proceeds could go to other approved costs that weren't related to your payroll. So long as you use 75% of the money on approved payroll costs, the other 25% could be used on other approved business expenses. And so long as you fell into that parameter and didn't reduce your workforce, then you could qualify for loan forgiveness. But there was a lot of talk that what would happen to the businesses who couldn't open, such as restaurants, gyms, movie theaters. What is the point of keeping employees on payroll if you don't need your employees because you can't open the business? So on June 5th, 2020, the Paycheck Protection Program Flexibility Act of 2020, or the PPP Flexibility Act, came into play. And while this changed a great many things, the biggest impact this had was that the percent of funds to be used on payroll cost was reduced from 75% to 60%. So basically, you could use more of the funds to pay mortgage interest, utilities, and less on payroll, because a lot of employers were having difficult time spending 75% on payroll when they really didn't need their employees. So Congress amazingly listened, and while, like I said, it changed many other things, the one thing I want to focus on is that your payroll costs or reduced from 75% of the loan funds to 60% of the loan funds. Okay, if there are no questions, next thing I want to move on to is force majeure clauses and COVID-19. It's been a long time since I've even had to analyze one of these type of clauses. Like I said, I've been practicing law since about 2006, and almost never, actually, I would say up until recently, never had I even had to read or think about this type of clause, but not anymore. So essentially, what is it? It's a standard clause found in most contracts that basically says if parties are unable to perform their obligations under a lease due to extraordinary events beyond their control, then the party who can't perform is generally forgiven of the right, or the obligation, I should say, to perform. Sometimes this suspension is temporary, and sometimes the suspension is permanent. Now, there are several things you have to look at when you're analyzing this type of clause. The first question is, how is a force majeure event defined? And once you figure out how it's defined, what rights and remedies are available under the agreement if a triggering event has occurred. So every agreement defines what type of event would trigger this type of clause in different ways. Most rental contracts are poorly written, which lead to litigation over what a triggering event is or is not. I can tell you most standard lease agreements I have reviewed generically define a force majeure event as war, riot, or the catch-all act of God. Now, the problem you run into is unless the clause itself specifically envisions a global pandemic, it's going to be very uncertain how courts interpret whether a pandemic would trigger a force majeure event or not. However, in my opinion, if your clauses use all-encompassing language such as act of God, I do believe that a court is more likely to interpret the force majeure clause being a pandemic. And depending on what the clause specifies as the landlord or tenant protections, those are the protections that were given. Now, given the fact that the pandemic is brand new, there hasn't been really any court decisions I can point to give anybody guidance on this. But within the last week or two, I believe we had our first court decision on interpreting a force majeure clause. Now, the problem is this wasn't a civil court who made this determination. It was a bankruptcy district court in Illinois. So while that doesn't have any binding authority on other courts, it certainly is persuasive. And what a bankruptcy district court did was it basically reduced the rent obligation of a debtor in bankruptcy by 75%. Because in that case, the force majeure clause defined acts of government that make performance difficult or impossible. The bankruptcy judge in that case found that the shelter in place issued by the governor was definitely an act of a governmental entity, which made this type of business, a restaurant, unable to function. So at least in Illinois, according to one bankruptcy district court, that particular force majeure clause did prevent the debtor from having to pay 75% of its rent. So if you're having difficulty paying rent, or if you're a landlord wondering, wow, how far can I push the payment of rent? What legs do I have to stand on to negotiate? The first place I would look in your lease before any place else is to see how this clause is drafted. Now, from my review of most commercial leases, most of these leases do not suspend the rent obligation. the standard force majeure clause in your standard commercial lease that you typically find at Office Depot specifically states that the rent obligation would not be affected by this type of clause. But if you had an attorney draft your lease or negotiate your lease, then you may have some added protections. So I would advise anybody who's having a difficulty paying their rent, whether they're the landlord or whether they're the tenant, I would pull your lease and look to see how this is defined, because it would be good bargaining chips on both sides of the equation. And even if your lease doesn't contain a specific clause, which it would surprise me if it didn't, California has codified this in Civil Code 1511 subsection 2. Although that's not nearly as broad as act of God, it does define a triggering event as an irresistible superhuman cause or by the act of public enemies of the state or the United States. I can't sit here and tell you right now exactly what a superhuman cause is or what an irresistible superhuman cause is, but I do think a good argument can be made that this pandemic is certainly a superhuman clause. We're just going to have to wait and see to see how courts interpret this. But this is another thing to keep in mind when if you're worried about paying rent, or if you're worried about your tenants giving you the rent. This is another protection I think that needs to be analyzed when both landlords and tenants are trying to come to the table and come to something that's a fair resolution. Because even though I hate this term, because I think it's overused and a cliche, we are in this all together. And a lot of these commercial tenancies are restaurants. You walk downtown Santa Rosa, you see a lot of restaurants either closed or they're open, but they're open for curbside pickup, or the amount of people they can have in their restaurant has diminished. The restaurateurs need help, obviously, because they're not making as many profits, but at the same time, the landlords, I wouldn't recommend taking a strong hand approach to any of this either, simply because it does no one no good to have a vacant spot. So I think everybody has to come to the table and truly figure out what's going to be best in the long term. Instead of making short-term decisions that might be good for your cash flow today, I think you need to definitely look at the long term and look at these more as a long-term business relationship and how it's going to help both the economy as a whole and individuals and property owners recover. So are there any questions on those type of clauses before we move into the main point, the CARES Act and bankruptcy? All right, seeing no hands, hearing no questions, and we are making great time. Wow, maybe I should talk slower. Okay, no one said anything. Okay, so the CARES Act has modified portions of the bankruptcy code to make it easier for some individuals to file for bankruptcy. One of the things the CARES Act has done is exclude stimulus payment from the exclusion of your current monthly income. And why is that important? Because when primarily individuals are trying to weigh whether they want to file a Chapter 7 bankruptcy, which we'll get into what that is a little later, or Chapter 13 bankruptcy, one of the triggering events to determine which path you're going to go into is the debtor's current monthly income. The term current monthly income excludes payments made under federal law relating to the national emergency declared by the president under the National Emergency Act with respect to COVID-19. So what does this mean? Simply put, this means that debtors do not have to include stimulus payments in their monthly income when figuring out their budget and when figuring out whether they would qualify for a Chapter 7 or whether the law would kick them to a Chapter 13. With this exclusion, presumably many more debtors would qualify for a Chapter 7, which is a straight liquidation and discharge of all eligible dischargeable debts. But even if you don't qualify for a Chapter 7, and we'll get into qualifying for a Chapter 7 versus a 13 a little bit later, even if you're in a Chapter 13, your monthly payment to creditors will also be less in a Chapter 13 because any monies received under this type of program are not considered in your monthly income. All right, what else did the CARS Act do? It made a temporary amendment to Chapter 13. The general rule is that a Chapter 13 plan is either a 3 or 5 year plan, and that really depends on whether your household income is above the median for a household of your size in California or below the median. It would either be a 3 or 5 year plan. But the CARS Act, under certain circumstances, has allowed debtors to modify a plan to a 7-year plan. And basically, who's eligible? Debtors who are experiencing or having experienced material financial hardship due to Chapter 19 can file to have their Chapter 13 plan modified to a 7-year period. The benefit to that is your monthly payment will be lower. So that means that you would have more available cash flow on a monthly basis. It only applies to cases confirmed before the date of the enactment, which was 3/27/20, and this is only a temporary fix. It sunsets after 1 year. So basically what that means is you have to be in a Chapter 13 plan that has been confirmed prior to March 27th. And then if you are experiencing financial hardship, you can modify your plan to 7 years. Now, I would certainly consult with the bankruptcy attorney to determine whether that is in your best interest, but that's certainly one of the options the CARS Act has given us today. Questions on how the CARS Acts affect bankruptcy? Okay. So now we're going to go into a oh-so-brief summary of Chapter 7, 11, and 13 bankruptcies. So, Doug, some of this should look familiar to you. First thing people ask, or first thing you should analyze is, just because bankruptcy is there, is it right for you? Is it an available option? And everybody is anxious. Everybody is anxious. Creditors don't know whether they're going to get paid. Debtors don't know whether they can pay their bills. And I represent a lot of tenants, and I also represent some landlords. And right now we're trying to work out rent, who pays rent, when, can rent be renegotiated, is it going to be temporary or not? But the one thing I've seen is that so long as you try to face these problems head on, if you can openly communicate, if you're a tenant, openly communicate with your landlord. If you're a landlord, reach out to your tenant. Nothing cures anxiety more than open and honest communication. Also, debtors need to have a plan, need to have a financial plan. Landlords should also have a financial plan. Times are likely going to be tough the next couple months or longer. So to have a financial plan and how you're going to survive might be a way to avoid bankruptcy. And then the other thing you have to do is show them that your business is viable. Show them that even though you might be having difficult times now, the future of your business is bright, and that your business is worth more open than it is closed. Because closing your business isn't going to help you, and it certainly isn't going to help the landlord. So before you consider bankruptcy, I think you should analyze and be open to these concepts. Plus, if your landlord is expecting a bankruptcy, they may be less hostile to you when dealing with you in the bankruptcy court, which can certainly be helpful. All right. This one I stole directly from Doug, although the pictures come from myself. So, bankruptcy basically offers two options. The Chapter 7 is what can only be referred to as a funeral, and that's primarily for businesses who say, I'm done, I either can't operate anymore, or I don't want to operate anymore. And you're basically turning the keys over to a third party, in this case, a Chapter 7 trustee that says, here's my business, liquidate and shut me down. Or if you think, you know what, I want to continue operating my business, but I just need a reset. I might need to readjust my debt. Well, not might, you definitely need to readjust your debt. I may need to establish or limit new lines of business. A Chapter 11, a Chapter 13, or the new Subchapter 5 can help you accomplish that. So before you even decide which chapter you think you might want to file under, it's critical that if you first figure out what is the goal for your business. If the goal is not to close your business, then you want to stay away from a Chapter 7. Because as a business owner, you can't operate your business when you're in a Chapter 7. So your only option if you're a business owner in a Chapter 7 is to shut your business down and liquidate. All right, Chapter 7 liquidations. For a business, and when I define business, I'm talking about a corporation and an LLC. A Chapter 7 is basically, as I said, an end to the business. A business comes under control of a Chapter 7 trustee who then stands in the shoes of the business owner or debtor. Chapter 7 trustee seizes the assets, liquidates the assets, and offers a dividend to your creditors. Depending on what your asset situation is, depending on your creditor situation, your creditors can get 2 cents on the dollar, 75 cents on the dollar. It really all depends. One thing worth noting, that in a Chapter 7, a business such as a corporation or LLC is not eligible for a discharge. So businesses cannot get a discharge. So that begs the question, why would a business file a Chapter 7 if the business can't get a discharge? Well, it depends. Some business owners I talk to don't want the hassle of having to contact creditors, having to shut the door, having to sell assets, having to give up assets, and trying to distribute this. They're done with the business. They want to get on with their lives. So what better way to do that? File Chapter 7, give the keys of your business to the trustee, and the trustee takes on the bulk of the work. It doesn't mean the business owner isn't involved in the process, and it doesn't mean that the business owner doesn't have to cooperate with the trustee. Bad things happen if that doesn't happen, but essentially you're turning the business over to a third party, and they are responsible for closing the business, so to speak, and liquidating the asset and paying a dividend to creditors. Now, if a business is a sole proprietorship and they file Chapter 7, some business owners think, well, that's a business bankruptcy. Well, technically, that's a personal bankruptcy because a sole proprietorship is not a separate legal entity. You are the business is you. So as a sole proprietor, if you file a Chapter 7 bankruptcy, that's an individual bankruptcy. Why is that important? It's because you may have assets that you don't want to lose to a Chapter 7 trustee. Now, as an individual, if you file a Chapter 7, you can do what's called exempt certain assets, which means that certain assets up to certain dollar amounts can be protected. That means you as the debtor can keep those assets. But anything that you can't exempt, that has any value to the estate will likely be seized by a trustee, sold, and the dividends distributed to creditors. So you got to be really, really careful, especially if you're a sole proprietor, whether you want to file a Chapter 7 or not. You might own a home that has $300,000 of equity in it. Chapter 7, unless you want to give up your home, would not be a viable option for you, but there would be other options under the bankruptcy code. So if you no longer want to operate the business, or a Chapter 11 is not feasible, then a Chapter 7 would be your only other alternative in bankruptcy. Some reasons why a Chapter 11 might not be feasible is the cost. Depending on what type of Chapter 11 you file, the cost can be substantial. Or your business, even if the debts are reorganized, even if leases are rejected, even if leases are renegotiated, even if interest rates are renegotiated, your business just might not be viable. The key thing in the Chapter 11 is that your plan of reorganization has to be feasible. It has to be likely that upon exiting Chapter 11 bankruptcy, you can operate a successful business under your plan. If you cannot, then a Chapter 11 won't work for you. So what is a Chapter 13? Those are generally known as a wage earner's bankruptcy, and this is where you see a lot of individual sole proprietors file. And a Chapter 13 bankruptcy is a personal reorganization. It's not available to businesses, so only individuals, including sole proprietorships, can file a Chapter 13. And why would you file a Chapter 13? The most basic reason is if you don't qualify for a Chapter 7, meaning if you make too much money. If you make too much money and don't pass what's called the means test, then a Chapter 7 is not viable and you would not be able to file one. Or the other reason you might file Chapter 13 is that you have unexempt property that you don't want to lose to the bankruptcy trustee. You do not lose any property in a Chapter 13 bankruptcy. That's another reason why you might want to file a 13 as opposed to a 7. Or you don't want to shut down your business. In a Chapter 13, you don't have to shut down your business. So that could be another reason. In summary, the advantages of a Chapter 13, you don't lose assets. You have much more control of your case in that you propose a plan of reorganization. You can challenge your creditors' claims. In a Chapter 13, creditors have to submit a claim, and that's their way of saying you owe me this amount of money. You can review those claims and determine whether you agree that you owe that money or not, and you can challenge them. But for individuals, the biggest reason why you would file a Chapter 13 is if you're behind on your mortgage payments. You can pay the mortgage arrears in a Chapter 13 plan over the life of the plan, whether it's 3 years or whether it's 5 years. So if you fall behind on your mortgage, you can catch up by making a monthly payment to your Chapter 13 plan that basically amortizes your mortgage arrears over 3 to 5 years. So that is a huge advantage for people who have fallen behind on their mortgage and yet at the same time don't want to lose their home. What are the disadvantages of a Chapter 13? You're generally in bankruptcy for 3 to 5 years. You have to commit all your disposable income on a monthly basis to your creditors. And you're under the supervision of a bankruptcy trustee for 3 to 5 years, which means that a bankruptcy trustee monitors your case. You basically make your payment to the bankruptcy trustee. The bankruptcy trustee then turns around and makes the required payment to your creditors. Every year in a Chapter 13 bankruptcy, you have to submit your tax returns to the trustee. And the trustee will take a look at your tax returns. And if your financial situation has improved, the trustee will likely make a motion to increase your plan payments. Now, the adverse is also true, or I should say the converse is also true. If your financial situation decreases, the debtor themselves can make a motion to decrease their plan payments. But you are under the guise of a bankruptcy trustee and court supervision for 3 to 5 years. And a lot of people don't appreciate that. All right. Now we're going to talk about some basics of a Chapter 11 general business bankruptcy. And what is a Chapter 11 bankruptcy? It's a reorganization for businesses. Typically, you see only businesses filing a Chapter 11, but individuals can also file a Chapter 11. It's just usually cost prohibitive to most businesses. So what does a Chapter 11 entail? In addition to the normal bankruptcy pleadings, which is a petition, schedules, statement of financial affairs, listing of your creditors, listing of your assets, listing of your leases, stuff of that nature. Also, you have to file what's called your general first day motions. And that can be a whole bunch of different things. We're not going to get into what every single motion would be on the first day, but generally what you see is a motion to for an order to allow you to use what's called cash collateral. When you file a Chapter 11 bankruptcy, just like any other chapter, a bankruptcy estate is created upon the filing of a bankruptcy. So you have to get court approval to spend certain monies outside the ordinary course of business, because the money belongs to the bankruptcy estate, not necessarily the business. So you have to file on the first day of your Chapter 11, or pretty close, a motion that allows you to use the cash of the business to continue to make business payments and to run your business. Your attorney will also file a motion to be approved as your attorney, and probably for approval of some type of attorney's fees. So there's a lot of work involved in a Chapter 11 at the really beginning. Also, later on in the process, in the general Chapter 11 bankruptcy, you have to file what's called a disclosure statement. You have to file a plan. You have to get the disclosure statement approved by the court. You got to get your plan approved by creditors. You got to review and object to proofs of claim. You got to analyze whether you want to assume or reject certain leases. And then the hard part, you got to execute and perform the terms of the plan. So advantages to a Chapter 11 bankruptcy generally are the automatic stay. That's a significant advantage regardless of what chapter you file under. And that's kind of a pause switch. Most collection activities upon the filing of a bankruptcy stop. Most lawsuits, most court proceedings upon filing of the bankruptcy stop. All collection activity stops, all lawsuits must stop. And subject to certain exceptions, if your creditor wants to continue to come after you, he has to seek approval from the bankruptcy court to come after you. So this is a huge way where a business can take a step back, stop all collection activities generally, and try to figure out the best financial path forward. In a Chapter 11, unlike other chapters, unlike Chapter 7 and unlike Chapter 13, well, strike the Chapter 13, but I won't get into that. Secured debts can be modified in a Chapter 11. You can modify interest rates. You can re-amortize your payments. Chapter 11 also allows you to avoid liquidation, meaning you don't have to sell your assets and shut down the business. It can allow your business or company for you to stay in control of your assets. Unlike a 7 or unlike a 13 where a trustee is appointed, generally speaking, in the general Chapter 11, a trustee is not appointed. The debtor remains in control of the business, and so long as the debtor follows the rules and does everything properly, a debtor will usually remain in control of the business. So it gives you more authority, gives you more control of your own destiny. Chapter 11 can also save jobs, and it can significantly reduce the debt of the company. while allowing your company to continue to operate over the long term. That essentially is the goal of a Chapter 11. Reduce or reorganize the debt, keep people on payroll, and to keep your company operational. What are the disadvantages of a Chapter 11? They are generally extremely expensive because there is a lot of work that needs to be done. They can be very adversarial. Creditors are battling with debtors, debtors are battling with creditors. A trustee, while normally not appointed, could be appointed for cause, or if it's determined that your plan isn't feasible or you don't properly perform under your plan, your case can get converted to a Chapter 13, and now your business is shut down and you're liquidating. Issues can become very, very complicated. There's absolutely no guarantee of success, and the debtor owes an ongoing fiduciary duty, not only to the company, employees, or shareholders, but also to the estate that's created and the creditors. So while you remain in control of your company, and while you remain able to guide your company, you owe a lot more duties to people you may not otherwise owe a duty to. Okay, questions on Chapter 11? That was very, very oversimplified view of a really complicated chapter in bankruptcy. All right, no questions. What time is it gone? We are just going through this quicker than I thought. Okay, so in February, a new Subchapter V of Chapter 11 went into effect. And this was a tremendous advantage for small businesses, because the goal of a Subchapter V, Chapter 11, was to streamline the Chapter 11 process and to make the process not only quicker and more efficient for small businesses, but to cut a lot of the cost involved. So businesses who normally would not be able to afford a Chapter 11 bankruptcy could likely afford a Subchapter V, Chapter 11 bankruptcy. So, like I said, it was recently enacted to help streamline and make more affordable a Chapter 11 to small business debtors. The key is small business debtors. As originally drafted, a business debtor was capped at a debt limit of about 2.7 million and change. But the CARES Act temporarily increased the debt limit to 7.5 million. So at least until around March of 2021, if you are a small business, the debt has been increased to 7.5 million total debt. So when you're looking at your business, if you have less than 7.5 million debt, then a Subchapter V would be viable for you. Now, when this sunsets, the debt limit is going to go back down to about 2.7 million. But until that happens, now's the time to take advantage of it. Now, there have been some grumblings from the talking heads that think that the 7.5 debt limit might be extended, or might be temporary, or might be permanently increased. I don't know if that's the case or not. But if you're thinking that a bankruptcy might be an option, and you have equal to or less than $7.5 million of debt, but more than $2.7 million of debt, now would be the time to consider whether this type of bankruptcy would be beneficial to you or not. The Subchapter V is extremely less complicated than the normal Chapter 11. There are less procedural requirements. There's no disclosure statement required, which in my opinion, that cuts an incredible amount of costs off. Because preparing a disclosure statement, you normally need to get accountants involved. You may need to get a person who values your business involved. You need to get your attorneys involved. So there is no disclosure statement required. And unlike the regular Chapter 11, where a debtor only has an exclusive period of time to file a plan. In the Subchapter 5, only the debtor has the right to file a plan. Your creditors do not have a right to file a plan on your behalf. The deadlines are much shorter, which should result in the case moving much quicker. And unlike the regular Chapter 11, where a trustee is not appointed, in the Subchapter 5, you do get a trustee appointed. But statutorily speaking, the trustee's role in the Subchapter 5 is very different than the traditional role of a trustee. In the Subchapter 5, the trustee is assigned and is almost, well, not meant, is meant to facilitate the flow of a resolution between a debtor and creditor. Now, there's not really any trustees that I know of in this, but to me, that almost sounds like the trustee is going to take more of a mediator's role and see if they can't help bring the parties together. That can be incredibly helpful, having a third party in there trying to facilitate middle ground. That's something you generally don't get in a regular Chapter 11, and you end up battling in court, spending a whole lot of money. Advantages of the Subchapter 5: it is significantly less expensive than a Chapter 11. The Chapter 11 trustee's role should be helpful and non-adversarial. And just like with the Chapter 11 and other forms of bankruptcy, the automatic stay that we discussed earlier should be a huge relief, because lawsuits generally stop, collection activities generally stop, and it gives you the breathing room needed to figure out what your business needs to do to be financially viable moving forward. What are the disadvantages? It's still brand new, and there's going to be many uncertainties along the way. I've been following district courts in the bankruptcy throughout the United States, and each district court is coming out with kind of different rulings on different topics. Because this is brand new, there's no appellate law really giving you any guidance. And while you arguably might be able to use some of the Chapter 11 law to argue persuasively what some of this stuff means or doesn't mean, none of us really know how the courts are going to decide some of these issues. So there's a little unknown to it. Creditors will likely still be adversarial. Just like in a regular Chapter 11, there's no guarantee that your plan is going to be feasible, and the debtor still has a heightened fiduciary duty to its creditors. All right, Subchapter 5 is an election made by the business debtor, which means that on your bankruptcy petition, if you decide this is in your best interest, only you as the business owner, only you as the debtor can elect to have the Subchapter 5 apply. If you don't check the box that says this is a Subchapter 5, then the regular general bankruptcy Chapter 11 rules will apply to you. So it's important to weigh and balance whether a Subchapter 5 is going to be helpful, a regular Chapter 11 is going to be helpful. If you're truly a small business and you're within the debt limit, I can't see how not electing to have the Subchapter 5 in most cases isn't likely going to be your best viable option. But only the debtor can make the election. Your creditors, the trustee, they can't force you into a Subchapter 5. All right, who is a small business under Subchapter 5? The debtor, according to the code, has to be engaged in commercial or business activities. Now, there have been some disagreement, of course, on what does engaged in commercial and business activities mean. I know of at least one district court case, forgive me, I can't remember which state it was in which that particular district court interpreted the intent of this to mean You don't have to be operating your business currently because of the shelter in place to qualify to be a Subchapter V debtor, because even though your business is closed, it's closed through no fault of your own. So we're going to deem you still engaged in commercial or business activity. But if your business is closed, will other district courts agree with that? I think it's a good argument, but I couldn't tell you how other judges would interpret this. Your aggregate debt limit, as we discussed earlier, is 2.7 million and change, but it has been temporarily increased to 7.5 million. 50% or more of your debt must arise from commercial or business activities. So essentially, this is truly designed for a debtor who is in financial distress, primarily based on business debt, not consumer debt. A small business debtor may be engaged in owning or operating real property. So if your business is meant to, because you operate and own real property, you certainly qualify, with one exception. Any debtor whose primary activity is owning or operating a single real estate small business is excluded. So if you're a single asset real estate business and that's your primary activity, you would not be a small business debtor under the new act. But besides that, these are the requirements. To summarize, your debt, at least temporarily, has to be no more than 7.5 million. 50% or more of your debt must arise from commercial or business activities, and you must be engaged in commercial or business activities. So how is Subchapter 5 different from a Chapter 11, a regular Chapter 11? Trustee is appointed in all cases, unlike the regular Chapter 11. There's different procedures, there's different plan deadlines, and I can't emphasize this enough, no disclosure statement is involved. Any of you who have any understanding of Chapter 11 would really appreciate, I think, the importance of not having to spend the time and extra money on a disclosure statement. The plan may modify some residential mortgages if you're, but I say some, it's complicated to determine, and not all residential mortgages are modifiable, but essentially, if your mortgage is not a purchase money security interest and the loan proceeds were primarily used in connection with the business, you will be able to modify your residential mortgage, but that's a very narrow. There are new cram down rules. What is a cram down? Essentially, a cram down is forcing your creditors to take less than what's owed. That's just a fancy bankruptcy way of saying, I might owe you $10,000, but you're going to get stuck accepting $3,000 or $4,000, and we're going to call it good. Your discharge in the Subchapter 5 is different, and it's dependent on what type of plan is confirmed. In the Subchapter 5, there's two types of plans. There's a consensual plan or there's a cram down plan. And unlike a Chapter 11, another big cost savings is unless the court orders otherwise, there's no creditor committee appointed. That can avoid a tremendous amount of litigation, and that can save a tremendous amount of cost. And if I haven't said it enough already, disclosure statements are not required. Small business debtor qualification, just to recap, 50.1% of outstanding debt must be business debt, and you must be engaged in business. Confirmation, that's a fancy word of basically saying the court approves your plan. In a non-Subchapter 5 small business debtor case, the standard Chapter 11 process applies, which includes what's called the absolute priority rule. And that's just a fancy way of saying in a non-Subchapter 5 Chapter 11, the business owner is not allowed to keep any equity in the business unless creditors are paid in full. In a Subchapter 5 business debtor, there's the standard secured claim cram down. There's no absolute priority rule, which means under certain circumstances, you can keep equity in the business even if unsecured creditors are not paid in full. There's the new disposable income requirements, and your plan term is generally going to be 3 to 5 years. In a non-subchapter 5 small business case, your standard discharge for a entity, meaning a corporation or LLC, is upon confirmation of the plan. So in the regular Chapter 11, if your plan gets confirmed and you're a business entity as opposed to an individual, the entity is discharged from the debt upon plan confirmation. If you are an individual in a Chapter 11, however, an individual does not obtain the discharge until completion of the plan. In a Subchapter 5 business case, discharge under a consensual plan is upon confirmation, and there's no distinction between entity and individual. And discharge under a cram down plan basically says upon plan completion, then the business entity or the individual gets the discharge, but it's upon plan completion. So it's just a distinction between consensual plan or cram down plan. All right, filing and timing of a Subchapter 5. Only the debtor, as I said, can file a plan, unlike a regular Chapter 11, where the debtor in a regular Chapter 11 is given a certain period of time to file a plan, and if they don't file a plan within that certain amount of time, then your creditors can file what they believe a plan should be. Can't do that in the Subchapter 5. And the deadline for a plan in the Subchapter 5 is 90 days after you file your petition. That's incredibly fast. That's much, much, much faster than a Chapter 11. So, in the Subchapter 5 plan, what's required? As I've said about 1,000 times, and you're probably sick of hearing me say, there are no disclosure statements required. However, the plan must contain information that a disclosure statement typically would have in it. The plan must include a brief history of the business operations, basically a liquidation analysis, and essentially you may need to get accountants involved in this, but essentially a liquidation analysis is just that. You're going to figure out what your assets are worth, and if you had to sell all your assets and pay off your creditors, you got to figure out what that would look like. Creditors need to know what they would get if you were liquidated. And there is a projection with respect to the ability of the debtor to make the payments. So your plan then has to go, all right, this is what I'm proposing. This is my business. This is the liquidation analysis. And you have to have a financial projection. So someone can look at your plan and go, you know what, this plan is feasible. This business can be feasible. This business can remain profitable. And it's likely that this business can make all required plan payments. So how is a plan confirmed in a Subchapter 5? There's two ways. One, consensual. That basically means all impaired classes except. What does that mean? An impaired class of creditors is a class of creditors who are not going to get everything they're owed. So if all your creditors, regardless of how much they're going to get, accept the plan is consensual. And the plan, of course, has to otherwise comply with the bankruptcy code, which is a topic for another day. What is another way of confirmation? Type 2 is a cram down. Unlike a regular Chapter 11, confirmation is permissible even if all classes of impaired creditors don't accept the plan, and the court can nevertheless confirm the plan even if your creditors don't agree with it. There's no voting on the plan. There's new cram down rules that you can, in the Subchapter 5, cram down debts, even if impaired creditors reject the plan. And as I said, it eliminates the absolute priority rule, which is a really, really big deal for equity holders in businesses. Okay, disposable income requirement. What must you pay into the plan? What must your creditors get? The plan must provide that all projected disposable income of the debtor to be received in the 3-year period after the first payment gets paid to the creditors. The code contains, however, no standard to govern how the court will determine whether you're going to have a 3-year plan or a 5-year plan. So that's one of the unknowns right now. How is disposable income determined? Disposable income is basically income that is not reasonably necessary to be expended for specified purposes. The maintenance or support of the debtor or a dependent of the debtor, a domestic support obligation, or payment of expenditures necessary for the continuation, preservation, or operation of the debtor's business. So that's basically how the code defines what your disposable income is. You basically take your gross income and you subtract out all the specified purposes. I might be oversimplifying that a bit. Okay, we went through that a lot quicker than I thought we would, specifically because I didn't spend the time I thought I was going to on SB 939. So I'd like to open it up for questions, comments, feedback.